Judgment in the appeal, Airtours Holidays and Commissioners for Her Majesty's Revenue and Customs.
This appeal is about the recovery of value-added tax. In October 2002, Airtours was in serious financial difficulties. It was suggested to Airtours that it should commission an accountant's report to satisfy the 80 or so banks and other financial institutions from which it had borrowed money, that its proposed restructuring and refinancing proposals were viable. The institutions were agreeable to this. Subsequently, pursuant to a decision in which both the institutions and Airtours were involved, PwC were appointed to produce a report. The terms of PwC's appointment were set out in a letter which, with the attached terms and conditions, constituted the contract. The contract provided that Airtours was to pay PwC's fees for producing the report and related work, and Airtours duly did this in due course. Airtours then sought to deduct the output VAT on those payments as input tax on its own VAT returns. Her Majesty's Revenue and Customs challenged Airtours' ability to do so on the grounds that PwC's services under the contract were not supplied to Airtours. Airtours did not accept this and appealed to the first tribunal, who found for Airtours, but the upper tribunal allowed Revenue and Customs appeal, and the Court of Appeal agreed. Airtours now appeals to the Supreme Court. The Supreme Court dismisses Airtours' appeals by a majority of 3-2, for reasons given by me in a judgment with which Lord Mance and Lord Hodge agree. In order for the VAT paid by Airtours to be reclaimable as input tax, it must be, according to the statute, VAT on the supply to Airtours of any goods or services. Airtours says that it satisfies this test for two reasons. The first is that PwC agreed, under the terms of the contract, to supply the services, and in particular to provide the report, to Airtours. The court rejects that contention. PwC's contractual commitment in the letter to provide the services described in the contract was to the engaging institutions, i.e. the 80 financial institutions, and not to Airtours for the following reasons, in brief. First, the letter is addressed to the engaging institutions, not to Airtours. Secondly, it refers to the fact that the institutions had retained PwC, no reference to Airtours. Thirdly, it provides that any reports are for the sole use of those institutions. Fourthly, it says that the report is to be provided to the institutions, and that Airtours is only to be provided with a copy, which can be redacted. And finally, paragraphs 9 and 10 recognise a duty of care on the part of PwC to the institutions, but does not acknowledge one to Airtours. It is true that Airtours had to countersign the letter, but that was to be bound by certain provisions, such as those relating to the payment of PwC's fees. The fact that Airtours was to pay PwC for the services can fairly be said to raise a prima facie expectation that PwC owed a duty to Airtours to provide those services. However, that is dispelled by the terms of the letter. The institutions wanted the services, and there's no indication that Airtours would have paid for those services had the institutions not wanted them. Airtours' second argument is that in any event it does not have to show that it had a contractual right to require the services under the contract to be provided in order for it to succeed. And given that it had a substantial commercial interest in the services being provided, and that it not merely countersigned the contract, but agreed to pay PwC for the services, justify the conclusion that the services were supplied to Airtours as well as to the institutions. Airtours rely on a statement in a 1999 case in the House of Lords that the question to be asked is simply whether the taxpayer obtained anything at all, used or to be used for the purpose of his business. But that observation has to be read in the light of later domestic and European Court of Justice cases, which show that statement should be interpreted consistently with the established approach of focusing on economic realities as the fundamental criterion for the application of VAT. It's clear from those cases that where the person who pays the supplier is not entitled under the contractual document to receive any services from the supplier, then unless the documentation does not reflect the economic reality, the payer has no right to reclaim, by way of input tax, the VAT in respect of the payment to the supplier. Lord Clark and Lord Canworth each give judgments dissenting on the analysis of both the contract and the commercial reality, but in light of the majority of view, the appeal is dismissed.